Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing of gum, or reading any materials, and no driving. Thank you.
Thank you, officer. This is case number 22-188-773. This is River Place Apartments LP versus Jamira Mathis. The matter is before the court set on for a pretrial conference date. The court previously established a scheduling order in this matter, and this is the return date in that regard. Your appearance for River Place Apartments, please. For River Place Apartments, counsel, are you there? Do I have Jessica Mathis on the Zoom? Say something if you're here.
I'm here, Your Honor. Oh, you said Jessica.
I said Jessica, I mean Jamira. Thank you, Ms. Mathis. Good morning to you.
Good morning.
I'm looking now for River Place Apartments, ma'am. Have you spoken with someone from their office this morning?
No, but my attorney Barrow, he's online. I don't know if he can hear us.
All right,
Good morning. I apologize. Attorney Ali Barrow present.
Your appearance, if you will.
Yes, Attorney Ali Barrow, P85907, Your Honor, appearing on behalf of Mrs. Mathis, who is present via Zoom.
All right, thank you, counsel, and good morning to you. Have you spoken with counsel on the other side of this, sir?
I have not. The most we have done is just exchange discovery requests and just filed some answers on that to that extent, Your Honor.
All right, very well. All right, got it. So why don't you take a moment, counsel, if you will, to reach out to that office and see if they're coming into the Zoom this morning. That's what I
Absolutely.
always do. If there are attorneys
Absolutely.
involved.
Give me one moment, Your Honor. Then let me reach out to them, please.
All right, so I'm going to pass on this one. I'll come back to it momentarily, sir. All right, thank you. Counsel. All right, the court now calls case number 22-190602. This is Jordan Ivy versus Denise Coleman, T-O-L-O-M-E-I. The matter is before the court regarding a subpoena. Do I have Irby on this Zoom?
Yes, sir.
All right, what is your name?
Jordan Irby.
Thank you, Mr. Irby. Good morning to you, sir. All right, this is, I'm also looking for Denise Coleman. If you're on this Zoom, say something at this time, ma'am. Just one moment, sir. Eric should reflect that the court did sign the subpoena in this matter, allowing or requiring that the defendant appear to offer testimony regarding this matter. This is in regard to a judgment that was entered in this case. That judgment was entered on the 17th of August of 2022. It appears that the defendant has not appeared at this time. Have you spoken with Mr. Coleman recently, sir?
No, sir.
All right, so the next step in this process is where the defendant has not appeared under the subpoena. The court will require that the defendant appear by way of a show cause hearing for the court to determine whether or not the defendant is in contempt of court and whether a bench warrant should be issued. Now, sir, do you have you accessed a show cause form? Or Mr. Irby, did you hear what I asked you?
I'm sorry. Can you repeat that? It cut it out.
Yeah. I'm setting the case up for a show cause. There's a form that you would submit regarding the show cause. Given that the defendant has not appeared for the subpoena, the next step is a show cause. The defendant does not appear at the show cause hearing, then the court would at that time issue a bench warrant. So that those are the steps in progression. Now there's a form that you are to submit that is a application for show cause form. Do you know how to access that and get that over to me, sir?
No, I don't know how to access.
All right, so you got that subpoena form from somewhere, right?
Yes.
All right, so there is the same place that you acquired that online, so where you could get a petition for show cause. I've already granted the petition, but there's a form that you need to fill out and get to me so that we can set up a hearing date on the show cause. And if the defendant doesn't show up, then there will be a bench warrant issue, and the sheriff's office would go arrest the person. They'd have to post the money, or they would be under arrest. Just so you understand how the process works, that's what happens next. Okay.
Okay.
If you can get that right away, I'm going to give you an email address where you can send that form
Mhm.
and get it. Right. So that email address is going to be. Go ahead and take it down now.
Okay, 1 second. Okay, I'm ready.
All right, yeah, the email address is going to be Carmen. The first name is Carmen, CARMEN dot. Last name is Banks, BANKS, at 36districtcourt.org. 36th, 36districtcourt.org.
District. So it's CARNEN and then BANK at 36districtcourt.org.
BANKS, put an S on that, Banks.
Okay.
And between Carmen Banks, you had to have a dot there, Carmen, and then a dot, Carmen.Banks
Okay.
at 36districtcourt.org.
Okay, got you.
All right, so I'll be looking forward to that form. It's a show cause form, all right?
Okay.
All right, get that to me, you get it signed up, and I'll give you a date on that form for that person to show up, and if you to show up. If they don't show up, then a bench warrant gets issued, and we'll go forward from there.
Okay, thank you.
Mr. Irby, I wish you well, sir.
Okay, bye.
All right, this is case number 22-193-983. This is Credit Acceptance Corporation versus Jessica Mathis and Antonio Mitchell. The matter is where the court set up a pretrial hearing regarding this matter. All right, your appearance for a plaintiff regarding this matter, please.
Good morning, Your Honor. Mike Olsey, here after the plaintiff.
Your P number, if you will, for the record, sir.
P81826.
All right, thank you, counsel. Good morning to you. And do I have Jessica Mathis on this Zoom?
Yes,
All right, good morning, Ms. Mathis.
good morning.
Good morning to you. I'm looking also for Antonio Mitchell. Is Antonio Mitchell on the Zoom?
He is not.
All right, thank you.
I wasn't told that he had to be on the Zoom.
What did you say, Dan? I didn't hear you there, ma'am.
I said I wasn't told that he had to be on the Zoom.
Oh, yeah, I'm not suggesting that he has to be. My inquiry was whether he was here or not.
Okay, no, he's not.
It looks like he hasn't filed an answer to the complaint. All right, counsel, the last time, I think the court issued a default, and I set it aside because it appeared that Ms. Mathis was in the wrong courtroom, that this electronic stuff, as a result of this electronic stuff, she was not able to be present at that time. And so I set it up for another, basically a status of scheduling conference. I have received a written document that's not in the form of an answer, but it is a response seemingly to the complaint in this matter. Have you received a copy of the written response in this matter, counsel?
Yes, we have, Your Honor.
All right, and just one moment, let me take a look at. All right, all right, so she makes reference, in the letter, to this, vehicle perhaps being a limit. All right, so, have you talked about this at all, in any way to, try and resolve this?
No, we have not had the chance to talk, Your Honor.
All right, so, who sold the vehicle? Let me see, I'm looking at the, just one moment. The vehicle was sold by a car, depot of Detroit, and then the financing was made through credit acceptance or through, through the creditor herein, and, it looks like it was financed by credit acceptance. So, basically, what happens, at least as far as that, the issue of, the car being a limit, is that there are rights that a person may pursue by way of going after the company that they have sold them a limit. The problem, in this regard is that, the creditor, simply loans the money for that transaction to occur. And the creditor is not, responsible to ensure that the vehicle is a suitable vehicle. That does not work to diminish the obligation that may exist with the creditor. You may have the right to go after the agency that sold you the vehicle under certain, laws in the state of Michigan that are referred to as limit laws. But when it comes to the, seller of the vehicle versus the financer of the vehicle, those are separate entities. I suppose that, a bit of discovery, in this matter, may assist in some regard. So I'm going to go ahead and set up on the, a discovery plan. So, ma'am, that's your basic position in this matter, is that, the vehicle did not work well, it did not last, and that you therefore think that you, should not have to pay for it for those reasons, correct?
Correct.
You do understand that the financing of the vehicle is separate from, the sale of the vehicle. You understand that?
Yes, well, I tried to give it back to the sales people. Like when the engine went out and everything, I had called them first to even see if they could recommend me to somebody getting it fixed. But the guy who sold me the car, he was so nasty to where I just told him like, okay, well, I don't even want the car no more. Is it a way that, like, I didn't even care about getting any money back. I just kind of wanted it to be clear or to see pretty much what was the best way that we can go for them to get their car back and for it to be kind of like, I'll say, see what I can pay to get it cleared off my credit. So we wouldn't have to pretty much come to this, but he was pretty much being just so rude about everything. So I just stopped calling him.
All right. So yeah, that's the challenge there. The challenge is that when you set up a financing agreement, the financing agreement, has to do with a third party. So you buy the car from one entity, and then you sign an agreement with a bank to give you the money to do that. And so this is not a bank or a finance company. This is a finance company suing you for the agreement to pay them the money that they gave to the automobile company in order for you to be able to get the car. So it sounds like your rights that you may want to pursue would be really against the company that sold you the car. Let me ask you, did you buy the vehicle as is? You know if you signed anything as is?
I believe so.
That could be an additional hurdle for you. How long did the vehicle operate when you got it?
Hold on one moment.
I want to say probably for 60 days.
And I'm looking at the financing document that it was a vehicle that you, looks like you paid about 17,000, and then there was, the finance charges that were part of this. So did you turn the vehicle back in at some point and, or the vehicle was repossessed? What happened?
No, it never got repossessed.
Counsel, any thoughts on this, sir?
No, Your Honor, just kind of, I mean, you laid out there pretty well in terms of, being two separate agreements and the financing agreement versus the, we haven't had the opportunity to, in regards to this, the defects of the vehicle, there's been, no discovery on it, but again, just reiterating your point about being two separate distinct contracts.
Let me ask you, do you think that trying to talk about this in a breakout room, that maybe you can come, maybe you can talk about coming to a number that might accommodate trying to get this resolved? Ms. Mathis, what it seems like is that you may be on the hook for the obligation because of the separate finance agreement. It might be worthwhile to try and talk about this and see if you can lessen the amount that they are seeking in this matter. Now, I don't know if I don't know if they will adjust that or not, but that would be something that the two of you could talk about. If it doesn't, if you can't find a way to try to get it resolved in that manner, then the court will set it up on the discovery schedule, and then at some point, likely what would happen is some type of motion will be filed to try to get the court to make a decision on the motion, because the facts are not in significant dispute. The party that might be obligated as it relates to the condition of the vehicle or problems with the vehicle, that would be the company that you bought it from. The credit acceptance, they just provided the financing for the agreement. So can we, I know I asked you a question, Mr. O'Cease, I want to take a moment and talk about this in a breakout room. If you can't get anywhere, both of you just click back into the courtroom, and then I'll go further with this matter at that time. So
Okay.
Here's the notification that I'm sending to you, and go ahead and take a moment to talk about it and see if there might be some room to resolve it. And I'll see you on the other side.
Sounds good, Your Honor.
Thank you, Mr. Barrow, and I'm back on the record regarding the suffix 8773 River Place Apartments versus Jamira Mathis. The matter is before the court set on for a pretrial conference. The court did leave discovery open through today's date. Why don't you go ahead and update the plaintiff in regard to where this matter is at this time, sir? Your appearance, first of all, for plaintiff.
Good morning, Judge. Christopher Asphalt, 53129 for the plaintiff.
Thank you, Mr. Asphalt. And I spoke with Mr. Barrow only to see what the posture of this matter was in terms of whether he had spoken with you. I want to hear from you. I know that there's been some discovery. Give me an update on where you think this matter is, and then I'm coming to Mr. Barrow, please.
Okay, Judge. Like you said, they have responded to my discovery, although they have not yet provided me with some of the written documentary evidence, which frankly is pretty critical in this case. So I assume they'll be getting that to me shortly. And once I get that, perhaps some more meaningful settlement discussions can be had, because thus far we haven't talked a whole lot, but we have not been able to come to an agreement.
That is correct, Your Honor. And I apologize. I did indicate to brother counsel that I was going to supplement my request to produce, and I do possess those documents now. And in fact, I was planning to supplement those today as well.
All right, so it looks like before the parties can get to any meaningful discussions about whether this can be resolved, then it seems like that final piece has to be taken care of. So if I set it over for 30 days and do a review at that time, I suspect the thought would be, the notion would be that you would know at that time whether I need to set it up for some type of trial, or whether you were able to work through some of the nuances. Is that about the size of Mr. Barrow?
I agree. I think 30 days is sufficient for me and brother counsel to discuss any type of resolution or, whatever is required to conclude this matter.
Mr. Asphalt, that makes sense to you, sir?
Yes, Judge.
All right, so I'm going to go ahead and advance the matter forward for about 30 days. That will allow discovery to be opened through that period of time. Of course, I'll extend it for 30 days. It seems that the party have made progress towards at least narrowing the issues and exchanging information. So I'm going to set the new date in this matter for I'll go ahead and set it for the 30th of March. No, that's a little bit farther than I want to be. Let me get that correct. That just one moment. So we'll actually set it for that's a problem. All right. Let's do March 13th. March 13th at 9:30 a.m. March 13th, 3:13, 9:30
March 13th at 9:30 a.m., Your Honor, correct?
Yes, sir. And I'm setting it for review at that time. And I'll look towards either a final pretrial conference if needed or setting on a trial date, and then we'll get it moving in that way on the next day. All right. I wish the two of you well. Thank you for being here. Thank you, Ms. Mathis. Good day to each.
Thank you, Judge.
Mr. Asphalt, we'll be in contact. Thank you, sir.
Thank you, Your
Okay.
Honor.
Ms. Mathis, you're free to leave. Thank you, ma'am.
Thank you.
All right. Case number. All right, this is case number 22-178867. This is Danita McCaskill versus the Rights of Gratiot LLC. The matter is before the court set on for a pretrial conference date. It looks like there are a number of defendants in this matter, and I did set the matter up for discovery to conclude today and set this on as a pretrial conference date. All right, your appearance for Danita McCaskill, please.
Yes, Your Honor. H. Russell Smith appearing on behalf of the plaintiff, Danita McCaskill.
Thank you, Mr. Smith, and your P number, if you will.
I'm sorry, P 35922.
All right, thank you, and good morning to you, sir.
Morning.
For the respective defendants, your appearance and just identify who you represent, if you will.
Good morning, Your Honor. Roman Fitzai on behalf of Carlton Bones and Boken Heating and Cooling, P numbers 47879.
Mr. Fasai, good morning to you, sir. All right, counsel.
Good morning, Your Honor. May it please His Honorable Court, Lance Mason, P number 4P43926, representing the Rights of Gratiot LLC, as well as the individually named defendant, Donnie Wright.
All right, thank you, counsel. So I'm looking, did we have any representation for Carlton Bowens or Jeff White?
Carlton Bones, Judge. He's my client. And Bowens, Boken Heating and Cooling. Both of them.
I got you. I see it now. What about Jeff White?
Jeff White's in default at this moment, Your Honor, along with Platinum Ducks.
All right, thank you, Mr. Smith. That was what I was getting at, just to address that particular issue. All right, so I see that plans. I see the defendant is filing a motion for summary disposition. And I see that there is something regarding a request to admit in this matter. Let me hear from the defendant that filed the motion. I'm not seeing the.
Yes, Your Honor. Lance Mason. I followed this motion, Judge. The basis of the motion is that I filed the request to admit. They were not timely answered. If this court recalled, I somewhat had some frustrations in terms of articulating to the court back in December how challenging it was to get information about some clarity in the case. And so what I did, I stepped back and, I filed a couple of pleadings just to get some clarity. He filed a multi-count complaint with, 40, 50 allegations. So trying to expedite the matter, I sent out a first and second request for production of documents, as well as some requests to admit. The request to admit was specifically related to the allegations in his complaint, as well as trying to narrow the issues in this case. In my pleadings to counsel, I emailed them to him. I've also, in my cover letters, indicated to him that these were requests to admit, first and second requests to admit. I emailed him as well as mailing them to him. And so what happened, and he didn't answer them within that time frame. There was no request for an extension of time. And if I couple that with my difficulty in terms of getting information, it's not like I had some trepidation about filing, but at the same token, this court is proceeding with this case. And my frustration on getting information, narrowing the issues to have meaningful conversations about resolving the case has been stunted based upon my inability to get documents in this case, Judge. And so I think based on the posture of this case, those admissions at a very minimum should be allowed to eliminate some of the issues that won't be to expedite a trial in this matter, should this matter go to trial. And it gives the counsel and I a basis to have some more meaningful conversation, because right now the complaint is just so full, it's difficult to tell where he's going in this case, Your Honor.
All right. And so your request to admit related to areas of in regard to the claims for breach of contract, negligence, fraud, rescission, and unjust enrichment.
Correct, Your Honor.
Your contention, Mr. Mason, is that the failure to timely respond to the request to admit should cause each of those areas of the claim to be cut off. Is that correct, sir?
Correct, Your Honor.
All right, so I'm looking now, before I come to you, Mr. Smith, looking, one second. All right. So yeah, I'm looking at the request to admit a document that was reportedly served in this matter. All right, Mr. Smith. Yeah, I see 23 items related to requests to admit, and counsel says that the response, if any, to those items was not within the time permitted by the court rules. Mr. Smith, you may at this time, sir.
Yes, Your Honor, I did not respond in the time required. That's not a question. The issue was I did not recognize them separately. He did send them, but that's not an excuse either, because they were separately marked. The request I had was that this court give some discretion. The requests were filed a couple of days late. They were before our last hearing. In fact, he was actually in receipt of those. So his questions of confusion about that are not accurate, I don't believe. Notwithstanding, they were answered. All the requests were answered, and then subsequently, Your Honor, the reason why we have an extension to today on discovery. Both counsel asked me for additional supplementation, which I did provide them with since then. The reason why I didn't file my own summary disposition motion was that I wasn't sure if they were still, if they were satisfied with what was submitted. But Your Honor, the court has the discretion, and I'm asking for discretion to have extended the filing of my answers to the request for admissions to the day I did, which was, I think, on the 31st or 32nd date, as opposed to the 28th date in this matter.
May I respond, Your Honor?
1 second, Mr. Mason.
Thank
So, and why is it that you missed that deadline, counsel?
I got 4 sets of discovery materials from Mr. Mason, and I got a similar set of discovery materials from Mr. Fitsai. And I just saw the tops of what was sent, and I just thought that Mr. Mason had only sent me interrogatories and not interrogatories and requests for admission. So when I was filing them, the interrogatories were of the same time period. I noticed that there were requests, and I answered them at the same time.
All right, so you were late on the interrogatory answers as well, correct?
Correct.
All right, Mr. Mason?
Your Honor, you know, and the same issue, without belaboring the point, the second set of interrogatories were not even answered at all initially. And mindful of what the court said when we met with the court, I professionally sent counsel a letter telling him that he did not answer the second set of interrogatories that was specifically addressed to every allegation that he had. So it was me who reminded him, even on the second discovery, under the penalty of me filing the motion to compel. So that's the history that I'm having in this case. When he said he provided me information, is on, like we got information on Friday, which is 2 days before today's hearing, just asking for clarity, a key as to what document he's sending us. So what happened, I got that key that he sent on Friday. And so we got cases proceeding. We all had other cases going on. Counsel filed this case. I find it kind of ironic that he's filed a motion for default against a defendant that's not in the case. He had no problems in following that deadline to make sure that that person cannot answer the complaint. My documents clearly said these are interrogatories, these are admissions. That was in my letter of correspondence that I attached to the pleading as exhibits. And so to say that, that goes to the level of cooperation that I'm trying to get. That's not the level that I'm receiving in this case. And so based on the history, and even the case law counsel has cited, that you have to balance the equities of the parties and us me trying to get some clarity in terms of whether the allegations are contained in his complaint. So I may properly defend this case and be able to advise my client of potential liability. And I just feel that in this case, it's unique that I can't get that information until after I resort to these methods. And so I think based on that posture, I still like to talk to counsel about resolving this case, but I think we have to have some sort of control in terms of not being at his whim in terms of what he wants to provide and when.
Your Honor, may I speak more?
1 second, Mr. Smith, and counsel, Mr. Mason, this was the items were what, 3 or 4 or 5 days late? Is that what it was?
I think they more like 5 or 6 days late. And that's frank, Your Honor. But if you talk, yeah, I won't respond to that other than to answer the question directly and say it's 5 or 6 days late.
I got your argument about the bigger picture. I just wanted to see if there was agreement on that particular component. I mean, discovery is a critical issue to the advancement of a case, and particularly where it is the plaintiff who has brought the matter, and then there is a request for information for admission. That's a significant issue, and it does put the court in a position where the court has to balance equities and obviously other issues in the case, the tendency to respond to discovery versus delays, perhaps the negligent management of a file. All of those things are factors to be considered, and then the various outcomes that may occur as a result of the court making any determination. Mr. Smith, you had something you wanted to weigh in on, sir. Go right ahead, please.
Yes, Your Honor. Well, the actual issue of cooperation, I did send him everything that he's requested. I literally did not see a second set of interrogatories, so I guess that was just an oversight, because the way he sent these documents, there were two separate days, about 2 days apart, where he sent these, and just like he says, I'm busy too, so I observed what was sent, and every answer to the request for admissions has been made. They were just a couple of days late. It was back before you extended discovery. We've had another 40 or so days of discovery. So the question of trying to figure out what's going on in this case, at least as far as discovery is concerned, is really moot at this point, Your Honor. The other thing, in terms of the actual questions he asked, none of them are dispositive of his side of the case. As I don't know if you received my brief, Your Honor. I did physically submit it, I think Thursday. The question is that nothing that's been allegedly admitted, if you want to consider that admitted, would resolve the case on his behalf, so that this case should still proceed notwithstanding.
All right, Mr. Mason, you get the last word in this regard.
Yeah, my position would be, Your Honor, just from a comedy standpoint, is that, I'm pretty fair. At this point, I'd like to be able to use those admissions to be, if this matter proceeds in this case, to be able to use, if the court is inclined not to dismiss, I'm asking for a dismissal, but if the court is inclined not to dismiss, then I would like those admissions to be used to limit the issues in this case, to have some meaningful conversations about how to really resolve the case. And I'm pretty fair, but that's where my frustration is coming from. And so what I'm doing is utilizing the court rules that I'm allowed to do, Your Honor. The only thing I'm doing is utilizing the rules to get some control as a defendant in a case that's filed with multiple defendants. So those admissions do go to the heart of some of the liability issues, not all, but some go to the heart of liability issues. And so maybe another conference where maybe counsel and I all have a chance to chat. For example, my client does have a contracting license, and that's been an allegation that keeps being thrown out here, but he's never requested information in discovery. So trying to get to that point is where I am, Your Honor. So that's my last words.
All right. One of the things that is utterly frustrating is discovery snafus that occur in a case where there are multiple parties and where there are allegations that have to be sorted out. Attorneys have to be on task to make sure that they are getting to those issues so that the case can advance at the proper pace and frequency that it should, and so that the issues can get narrowed. I do regard Mr. Mason's approach in this regard, in that he is almost pleading that let's just get to the issues and find out what's going on in this case so that we can try and get this resolved. And something as simple as request to admit that could turn into a one-word answer in many instances: denied, not true, 2 words. It turns into a delay, taking up court's time, and so on and so forth. My determination is that when I look at all things considered, that the answers were late, they were delayed. I also take into consideration that Mr. Smith, at least in the context of this hearing, has not tried to cover up the reality that existed here, that it was something that he missed, that he did not see, perhaps a little bit more diligence he would have been able to see, but he didn't see it initially. He responded to it within a few days of the requirement. The court rule doesn't give a few days after, but it does give the case law does give the court the right to take some consideration as to the horizon, the circumstances, etc. And in that consideration, the court then will determine that a sanction is in order in this regard. Now, Mr. Mason has asked that the sanction be that that the request to admit be admitted, and that whether they lead to the dismissal of the case or not, that he would like the case dismissed, but that he would like to have the advantage of being able to have those issues clarified.
Your Honor.
1 second, the court is given the option to plaintiff's counsel in regard to satisfying this with a sanction that has been issued by. All right, Mr. Smith.
Could I get at least 2 weeks? The reason why I've got to pay my property taxes today in the city of Detroit, and it's going to be a problem for me in 7 days.
All right, Mr. Smith, I'll grant the 14 days to resolve that payable to Mr. Mason in this regard. If it's not paid, then of course I'm granting the motion for summary disposition. If it's paid, then the court will allow the answer submitted 3 to 5 days after the due date. All right. Other issues at this time?
No, I will say for the record, Your Honor, that I will reach out to counsel and have meaningful conversation with him about the relevance of the issue and what can we do to resolve it. That's always my intention, Your Honor.
Yeah, and I think obviously that becomes more important for all parties involved when you have when you have multiple parties, particularly in this case, you got multiple defendants. And I think I looked at the claim in this case, and it looks like the principal amount of the claim is $7,250. And at least I think that's, if I'm looking at this correctly.
Yes, it is, Your Honor.
Yeah. So, I mean, yeah, you don't want to, I practice law, okay, $7,200, multiple parties, 3 attorneys involved in this. Get to the issue and let's figure out what's going on here. Of course, the plaintiff wants to be here because the plaintiff feels that they need to be here. Defendants are not interested in being here. So any delays makes it that much worse because they don't want to be here anyway. But that's how it works, when your client is getting sued, you don't really want to be there. When your client is sued, that's exactly where you want to be because you want relief from the court. So this discovery stuff just kind of drags that along a little bit. All right, Mr. Fasai, anything that you need to bring to the court's attention at this time? Anything you're requesting as we try to go forward and move this into some kind of position to get to the bottom line, sir?
Well, we don't have any specific requests at this time. Our supplemental responses were just recently received. And again, the argument is obviously they weren't timely made. I would concur with Mr. Mason with respect to his position in this matter. Given the amount involved, it's still not very clear what the total amount involved is. I mean, the court just read $7,200, but in the plaintiff's complaint, there's 2 separate requests, and it appears like the total claim is about $16,000. So we're not totally clear what even the total amount of the claim is. So, perhaps Mr. Smith can clarify that for the record for us, what his total damage amount is.
Yeah, Your Honor, the only question I'm puzzled by these gentlemen. When you go to district court, you have to give a precise amount of what you're asking for in your complaint. You can't just have a general damages request, and it's listed there. I supplied discovery related to the amounts that are over the $7,200. There's actually some more that I've discovered since, but we're not asking for it. It wasn't in the complaint. So, I'm just saying we didn't do that. So there is the amount is listed in the complaint. I don't know if you're willing to engage in the conversation, maybe I can try to get to the bottom of that, and if that's what you want to do.
Well, unless I heard incorrectly, Mr. Smith indicated that the total claim was $7,200, Yet the complaint, the way,
Pri- He said the primary claim was 72, whatever the judge said. I answered the judge's question, but I said there was additional damages for cover of $8,100. That's where the other amount.
That's where, and looking, my look at the complaint, it confused me because I'm looking at 8,000, something over here, and then I'm looking at a prayer for relief that relates to $150. And I really just looking at the face of the complaint could not tell what the damage claim is in this case. So Mr. Preside says that. I think,
Okay, well.
I mean, that's my judgment in looking at it. But you mentioned earlier when I said that I felt a bit of relief there. You said it was that is the claim.
Okay, well, maybe I'm just not good at English anymore, Your Honor.
I wouldn't say that. The complaint seems a little bit this is not any terms of art, but it seems a little bit jumbled in there. There's a lot of stuff there. But again, that's what discovery is for, is to kind of, sort that out. And, we all have filed complaints that have a lot of stuff going on. And maybe that's because, we're still researching all of what is involved. We get it. Once you get into discovery, then you kind of got to lock that down and narrow what it is so that everybody is at least swimming in the same direction in terms of what the parameters are. And I think that that's a bit of a concern here. Now, I'm hoping that, and I'll go ahead and set a next date in this regard. I'm hoping that we can get past the discovery issues to get to where the heartbeat of the case is, because then maybe the parties can resolve whatever the challenges are here. Sometimes when you have a case that has a whole lot of money involved, it's one big problem. Sometimes when you have a case where there's not a lot of money involved, it's a really big problem. So, the amount of money doesn't necessarily simplify things at times. So nobody's trying to diminish the case by virtue of the dollar amount. But when you have 3 attorneys involved, and you're talking about $7,500, you have 3 attorneys and 5 or 6 defendants. Well, we need to talk. We need to talk about that and see if there's a way to get to the geometric conclusion, shortest distance between 2 points, a straight line. So we're trying to find a straight line here. And we're not talking about attorneys that started yesterday either. So that's another part of it. So gentlemen, I'm going to set it over. I'm going to go ahead and set it over for about 30 days. That's going to bring it back before me. I'll go ahead and set it on the 6th of March. March 6th.
Your Honor, can we pick a different date? I'm out of town that week. I'm not available. Maybe the 13th or
the 13th. 3/13.
Yeah.
20. And I'm setting this at 10 o'clock a.m.
Thank you, Your Honor.
All right. And let's see where we are then. I'll determine then if we need to set a trial date or evidentiary hearing or motions or whatever we need to do at that time. If you file a motion, remember the rule in front of me always is that any date that you have coming up in front of me, you can file a motion and set it for hearing on that date. The one requirement, make sure the other side has at least 10 days before the hearing to respond. That's a dispositive motion, whatever. If you file that motion, that is my rule. And I know that we have court rules that govern how you do summary disposition, but the court can issue rules that are different for a particular case. So that if you have something that is dispositive, you can set it for hearing on the 13th of March. The one requirement is that you got to give the other party at least 10 days notice before the hearing to respond to your motion. And I'll hear it on that day.
Thank you, Your Honor.
Judge, what time on the 13th?
10 a.m.
10 a.m. Okay, great. I didn't hear it. Thank you.
Thank you, Your Honor. Have a great day.
Have a great day. Take care.
I can't say thank you, Your Honor, but thank you.
Have a good day, Mr. Smith.
Okay.
And I'm back on the record in 3983 and want to thank you, Mr. Olsis and Ms. Mathis, for taking a moment to go out and try and talk about this at least. And good morning to you once again. We're back on the record in this regard. Council, at my direction, there was a discussion. Update me at this time if you can, sir.
Your Honor, I'm happy to report that we were able to, Ms. Mathis and I were able to come to a resolution. What we agreed to was a conditional dismissal with an installment payment plan. With the payments will be beginning on March 10th and be owed on the 10th of each month thereafter in the amount of $250 until paid in full. And of course, if there was a default in that payment, then the order would also say that the conditional dismissal will be set aside and a judgment for the remaining balance would then be entered in a plaintiff's favor.
All right, Ms. Mathis, you had an opportunity to talk about this, and you've been able to reach a resolution that results in the case being conditionally dismissed and the commencement of payments towards resolving this at $250 a month, starting on March the 10th. Is that in fact what you have agreed to regarding this matter, ma'am?
Yes.
Anything you wanted to, excuse me, anything you wanted to bring to my attention at this time?
No, but I do have a question. I wanted to know, is it a way, well, or is it possible for me to get the truck back and that knock something down off of the payment? My question to you, I would say.
That's something I don't have authority for.
Oh, okay.
Yeah, it sounds like there's been a decision to not repossess the vehicle and put it in auction, and so that's why that hasn't occurred to this point. And Mr. Ortiz has indicated that his client is not interested in doing it that way. So that's an industry standard kind of thing. A lot of times the vehicle seems to be operational and something that value can be gained from. Sometimes it will be repossessed and sold, but those are business decisions that are made. And then the final thing I'll say about that, because I'll sign off on the dismissal and then the parties can go forward as they've agreed, and that will bring this case to an end. At this time, it could be reinstated if there's a failure of payments. If Ms. Mathis chooses, she could, one of the things you could consider doing is bringing the vehicle to some state of repair and then marketing it, selling it, and using those proceeds to resolve the case or to pay towards the case. But then again, that's a decision that has to be made by yourself in terms of how you go about that. All right, so I wish both sides well. I will sign the appropriate paperwork. The council, you can submit that paperwork through email if you wanted to do so by mailing it to Ms. Carmen Banks, C-A-R-M-E-N, Carmen.Banks at 36districtcourt.org.
What? I'm sorry, what was that? Carmen.Banks?
Yes.
And Your Honor, the other thing too that I was going to propose, just for the simplicity of it, was to, and I explained this to Ms. Mathis off the record or in the breakout room as well, is that, and I'll email this order to you, but we were just going to file it under the 7-day rule. Just so again, because there's been just issues in the past of being stuff sent in the mail and not coming back. So the order is just going to exactly state what was just stated on the record. And then if no objections were filed, then the court could just enter it. Do you have any objections to that, Your Honor?
No objection to doing it that way. Of course, Ms. Mathis will be sending a copy.
Yes.
The document sent to the court, and then she'll have 7 days to object if there's something in there that was not agreed to. And if she objects, I'll set a hearing. If not, the court will sign the order after 7 days.
Okay.
So do it. Okay. All right. I wish you well. All the best to both sides.
Thank you, Your Honor.
Thank you.